Welcome everybody to this tutorial session of LB101 semester 2 for final exam, and this is for sec2 by Ajahn Pinay. So in this tutorial I will be covering some topics that we have learned in this semester, but it won't be all the details. So these are the topics that we will be covering today. So first, voidness and nullity. Second is the restitution. Third is contract. Fourth is effects of a contract, and next we have effects of a contract to third persons, termination of a contract, choices of remedies, and lastly we have effects of the termination of a contract. So the first topic we'll be covering is voidness. So if the JA is void, then it cannot be ratified. And you can read the section at section 172. And if a JA is void, it is considered non-existent from the beginning. But there is also a voidable JA, which is valid until it is avoided. So a person would have two options. First is to ratify the juridical act, and second is to avoid the juridical act. So if a person ratifies it, the JA become valid. But if the person decides to avoid the JA, then it will become void. And when it becomes void, this will have applied instead. And like this one said, after the voidable JA is avoided, then nullity comes in. So it will be considered to be non-existent from the beginning, and also come in the restitution. And the interested person can invoke its voidness or nullity. So the interested person in this case is a party or an heir of a deceased party. Is when a party in a contract is dead, so the heir will be the interested person because they have to deal with the deceased party murder, right? And also the party creditor, เจ้าหนี้ of a party. They are all the interested person who can invoke the voidness and nullity of a JA. And when a juridical act is avoided, the return of property is a consequence from the voidness of the JA. So the parties have to return the property under the rule of unjust enrichment. There are three forms of restitution. First is full restitution, second is partial restitution, and third is no restitution at all. So when a party acquires something from the JA, and when the JA is avoided, that other than an amount of money, then the person who received it in good faith will not be responsible for any damages, and have to return the property only in the condition that it already is, and they don't have to return anything more than that. But if the person received the property in bad faith, then they have full responsibility of all the damages, and unless they can prove that they didn't acquire the property in a bad faith. And also, if the restitution become impossible on account of the nature of the property received or on account of any other cause, and the person has received the property in good faith, the person is required to make restitution of unjust enrichment only in respect of the part which remain in existence. So at the time of the restitution, if the person who has received the property in good faith have the property, but it's not possible to return the property in good condition or like with no damage, on account of like the nature of the property that they receive or any other natural cause. Then the person who received the property in good faith make restitution only in the part that would still remain in existence. But the person who received the property in the bad faith, however, will have to pay full value of the property. And if the property that they have to return is not possible for restitution, then that's when the compensation comes in. So compensation by ways of damages. So this occurred when restitution is impossible. For example, when the property is destroyed, sold to the third party, or it is services that cannot be returned, then they have to pay for compensation instead. And what about the fruits of the property? That's subject to a void contract. So if a party receives the property in a good faith, then the fruits of such property, the person will be able to keep it and doesn't have to give it back to the other party. And these are the cases with no restitution at all, which are that when a person performed an obligation he knew he didn't have to perform. So when a person know full well that he did not have to perform such obligation, but he did anyway, so in that case he can't claim for any restitution at all. And second is the violation of a statutory prohibition of good morals. So in this case, it's against the law, it's illegal, so that person would not receive any restitution. And also, just a reminder that avoidable act upon avoidance shall be deemed to have been void from the beginning, and the party shall be restored to the original positions. If it is impossible to effect such restitution, the party shall instead be entitled to damages in compensation therefore. So this is basically like the whole restitution thing. On to the second topic, we have contract. So first, general nature of contracts. There are two types of contracts. First is bilateral and second is multilateral. So first, bilateral is a contract between two parties, and bilateral is a contract between more than two parties. And definition of contract. So contract is where there is a meeting between an offer and an acceptance. So begin with the mirror image rule. So if we have a little example here. So if A offered to buy B's car for 600k baht and B accepts A offers and sold the car for 600k baht, just as the same as what A asked B for. So this situation, this is called unqualified acceptance. The B acceptance called unqualified acceptance. So unqualified acceptance is when there is no modification from the original offer. So because A offers to buy B's car for 600k and B accepts A offer without changing anything in the offer. So that's called unqualified acceptance, or in Thai it would call คำสนองที่ไม่เปลี่ยนแปลงจากคำเสนอ and what is an offer? An offer happens when a person there is a person declaration of intention. And what constitutes an offer? So there are two conditions to make a person declaration of intention become an offer. So the person in declaration of intentions or the offerer declaration of intentions has to have clarity in the declaration. So it has to be clear that the offerer wants to offer something to someone. And second condition is that the readiness to be bound by such intention. So the offerer has to make clear in his statement that he wants to be bound by such intention. And we have a little bit of information here. So in Thai law, the prior price indication is not needed for a declaration of intention to be clear. However, the price must be reasonable in that case. So there's no need for a prior price notice, but in that case, the price should be reasonable enough for it to be understandable, for it to not need it in declaration of intention. Invitation to treat can be confused for an offer, but there is a difference between invitation to treat and an offer. So invitation to treat, different from an offer, has no readiness to be bound to the offer. So a person might present something to the other person, but he himself has no readiness to be bound to the offer. It's just to invite the other person to enter into a contract. So there's no indication of wanting to be bound to the offer. So sometimes it's also put in documents like these clauses that the person or a firm or a business put in their emails or websites that they have no intention to be bound to these catalogs, have no intention to be bound to this invitation to treat. So catalogs are not an offer, but an invitation to treat. And in that case, the customer are the ones who make an offer to buy, and the seller is the one to accept the customer's offer instead. Unilateral contract made to the whole world. So this one is a bit confusing. So it is an offer made to the public, to everybody who fits in a certain condition, and it requires no acceptance. So there's no need for the public to accept, because there's no way the public can accept. So the act of acceptance can be that the person come forward to show themselves that they fit into some kind of conditions that the offerer made previously. So if a group of people fit into that conditions and they come forward, then that itself is an act of acceptance, and that's require no verbal acceptance. Revocation of an offer. So there are two times that the offerer can revoke his offer. So first is before the offers becomes effective, and second is after the offers becomes effective. So if the offer itself has the period of acceptance that is specified in the offer, then let's say 1 week for the other party to respond whether he will accept the offer or not. If the offerer give the other party 1 week, it is specified in the offer, then in that period of 1 week, the offerer cannot revoke his offer. And the second one is the period of acceptance is not specified. When the period of acceptance is not specified, there will be no revocation until the period of time in which the notice of acceptance is reasonably expected to be received. So if the reasonable period of time that the acceptance is expected to be received is not end yet, then there would be no revocation until then. But it also depends on the mode of communication, so whether it's instantaneous or non-instantaneous, and that would concern what we already studied in the first semester about the time effectiveness of a declaration of intention. And that's had to do with that, because the time in which the offer is received by the receiver depends on whether the parties are in each other present or not, and that's gotta have to do with like the mode of communication. And also section 357 said that any offer, if a rejection thereof is made to the offer or no acceptance is made within the time specified in 3 foregoing sections, shall thenceforth cease to be binding. So if there is no acceptance or the offer has been rejected, then after that the offer will cease to be binding. Traditional approach and modern approach. This has to do with how offer and acceptance kind of interact with each other. So the traditional approach said that if there is any modification in an offer, then that means a new offer immediately, because the details change, then new offer. But in the modern approach, to aid the negotiation in the business scene more, if there is a non-material modification, like a trivial non-material modification, then there's no need to make a new offer. There's no new offer. It's still the same offer, just a little bit change, and as long as it's not material, then there's no new offer. And material alteration is like if the modification doesn't materially alter the original terms of the offer. So the important factors, the essential parts of the offer, if there's no change that touch on that, then there's no need for a new offer. And because this is also because each party used his own forms. So if like 2 firms communicate and they use their own form, and there would be a modification, big or small, there will be a modification. So to just make it easier for the businesses to negotiate with each other, the modern approach kind of have been used to this day. The next topic is the effects of a contract. So when a contract is made, there are obligations for both parties to perform, and it is a required performance. So the non-performance of obligations will result in breach of contract, and therefore the other party will receive remedies. So there are 3 types of remedies. So they can claim damages, demand specific performance, or terminate the contract. And there is this important right, that is the right to withhold performance. So when the other party does not perform his obligation, then when a party does not perform his obligation, then the other party don't have to perform his obligation back. So for example, um, A and B is in a sale contract. So because A has not yet paid for a property that he wants to buy, then B doesn't have to deliver the property until he is paid. So because A has not paid yet, B has the right to withhold his performance in delivering the property. So until A pay for the property he wants to buy, B can withhold the performance, the obligation performance on his part by not delivering the property. But the right to withhold performance only applies to contractual performance and not a performance that is required by the law. So that is something that the law kind of force the person to do. So this only applies to contractual performance and not any performance that is required by the law. One cannot withhold the performance if it is required by the law. The third point in this topic is the risks of loss of or damage to the property or impossibility of performance after the conclusion of a contract. So there are three types of way to go about this. So first is if a contract is about a transfer of a real right in a specific thing. A specific thing in this case means that the thing that is subject to the transfer. Yeah. If that specific thing is lost or damaged by a cause which is not attributable to the debtor, the creditor has to bear the risk. So who is the debtor and who is the creditor? The debtor is the transferor and the creditor is the transferee. So the debtor is the one who is required to do an obligation by transfer of specific thing to the creditor or the transferee. So in this case, if it is a contract about the transfer of a real right in a specific thing, then if that thing is lost or damaged by a cause that is not by the debtor by any means, then the creditor has to bear the risk. So if something happened to that specific thing that is not the debtor's fault, then the creditor has to bear that risk because he already buy the thing or like already sign up for this transfer of a specific thing. So when he's already in it, then he has to bear the risk. So which cause can be attributed to the debtor? So it can be the debtor's or the transfer's negligence. So maybe like how the debtor handled this specific thing. If he didn't handle the thing well, and it can be proved that the loss or damage to the property is by a cause that is attributed to the debtor, then that will be another story. So second is a transfer of a real right in a specific thing, the same thing, but with a condition precedent. So the same thing, a specific thing that is a subject to the transfer is lost or damaged before the condition is fulfilled. The debtor shall not bear the loss or damage of the specific thing. So what is the condition? What is a condition? Condition is like the time set by the parties of when the contract become effective or cease to be effective. So there are two types of conditions. First one is when the contract become effective. That is the condition precedent. And the second is when the contract ceased to be effective, and that is called the condition subsequent. And it is said by the section 182 about like what is a condition. And yeah, we have a little example here. So A will sell his car to B when A's father pass away. So the problem is that the car is stolen before the A's father's date. So this is the condition. The condition is that A will sell his car to B only when his father is passed away. The condition precedent is his father's date, and it is not fulfilled yet because his father is not dead yet, but the car is already stolen. So to conclude, since B or the creditor has not yet to receive A's car due to the condition precedent because A father is not dead yet, so B haven't received the car. B hasn't received the car. So he is not the one who has to bear the loss of car. So because as I stated above, that the creditor bear the risk when he's already signed up for the transfer of a real right in a specific thing. But because in this case B or the creditor is not really in it because of the condition precedent, because they already agreed previously that the contract will only become effective once A's father pass away. So subsequently B is not the one who has to bear the risk, and A, who is the debtor, has to bear the loss of his car instead. And if the loss of the car is A fault, which is the debtor, there are two choices for B, who is the creditor. So first, B can claim compensation, and second, B can terminate the contract. When the specific thing is not totally lost or destroyed, but is damaged, then the creditor can demand the continuity of the performance with reduced counter performance. Counter performance is what the creditor gives back to the debtor in exchange for his performance. So maybe the creditor have to pay less. So if the property, the specific thing is damaged, but it's not totally lost or destroyed, just it's already there, but it's not fully capable of its original ability. So in that case, the creditor can demand for the continuity of the performance, but maybe they gotta pay less because it's already damaged. Or the creditor can terminate the contract. The creditor can also claim compensation if the cause of damage is attributed to the debtor. And the last one here is when the contracts fall in neither case 1 or case 2. So it's not this one, and it's also not this one. What that just mean is that a case that fall on neither of two foregoing sessions means that the contract that is not made to transfer a real right in a specific thing. When that contract becomes impossible of performance by any cause that is not attributed to neither of the party, then the debtor is really relieved from his obligation, so he doesn't have to perform anymore because it's impossible to perform. and the creditor does not have to pay for remuneration or counter performance because it's by the cause that is not attributed to neither of the party, it just happened. But if when a performance that is not a transfer of real right in a specific thing is made impossible by a cause attributable to the creditor, then the debtor is entitled to counter performance or remuneration, for example, and the debtor is relieved from the obligation as well. Because it's impossible, the debtor can't do anything about it, but it also kind of wastes his time and stuff, so he is entitled to counter performance by the creditor. However, it's also important to note that if there is anything the debtor acquired from the release of the obligations, the deduction shall be made to the counter performance by the creditor. So because there might be something that the debtor acquired from the contract that when there is the release of obligations, the debtor kind of acquired that freely, so there would be a deduction that's made on the counter performance by the creditor, so that the creditor doesn't have to pay full remuneration, for example. Effects of contract to third persons. This is a short topic, just about like how the third persons benefits from the contract. So in section 374, it is stated that if a party in a contract concluded agrees to render performance to a third person, the third person is entitled to demand the performance directly from the debtor. In the case mentioned in the foregoing paragraph, the right of the third person comes into existence as from the time of his declaring to the debtor an intention to take the benefit from such contract. So the third person has no obligation. The third person demands performance from the debtor, and the right of third person exists once he declared to the debtor his intention to take the benefits from the contract. And there is also a provision in section 375 that is a protection of the third party interest, that after the right of third party come into existence, then no party in the contract can modify such right. And when the debtor raised defense under the contract, the debtor may invoke such defense against the third person. So normally the right or interest of third person is protected by the law, but if the debtor raised defense under the contract, then he may also invoke such defense against the third person. So for example, if the contract was made under fraud, then originally this third party who should receive the payment by the debtor as agreed in the contract would not receive any payment if the debtor raised his defense and invoked it against the third party, because the contract would be voidable if it was made under fraud. So if the debtor raised that issue and then the third party who is benefiting from the contract would not receive the benefits of the contract. So it is stated in section 376 above this that it may invoke against the third party receiving the benefits from the contract.